Yeah.
Oh, I didn't see that. No, that is.
I was like,
Yeah.
I think that's church.
This is out of California.
It's like a big old.
They do it all the time. I just pull around and park somewhere else. And like, it's whatever. I don't care.
It's kind of fun. What?
Good evening, everybody. Welcome to the November 16th, 2021 County Commissioners regular agenda. I'd like to call the meeting to order, and Commissioner Rivera. Here. Commissioner Ringston. Here. And Commissioner Ghosts are also here. Would you stand and join me for the Pledge of Allegiance, please? I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So just a little heads up, we have microphones in the ceilings, and we're live streaming this on YouTube. So if you have a side conversation, it's apt to be picked up and broadcast. So just to give you a heads up on that. And item number 3, public hearing is none. 4, any comments from the public? I'd entertain any comments from the public, please.
Mr. Chair.
Go ahead, Mr. Hinckley, floor is yours.
Okay, thank you. Yeah, Bern Hinckley, 508 South 11, Albany County. Since I've been interested in aquifer protection for many years, and since several folks at the aquifer hearing challengingly asked who wrote these regulations, I thought it might be useful to share a little history on the point, at least as I've been able to observe it. The first thing we need to remember is that the previous regulations did not come from Planning and Zoning Commission, even as a draft. Although P&Z had worked on the regs for about a year, the County Commission at the time tossed that work aside and adopted a whole different set of regs brought in by Commissioner Kennedy. And I think notably, nobody asked who wrote these really, and there wasn't a whisper of, oh, you have to go send these back to P&Z to get their approval. Kennedy was elected to County Commission, fair and square. They're the ones who make regulations, which they did, approved on a 2-to-1 vote, done deal. So that's where we were 3 weeks ago. The process for these latest revisions was way more transparent. Even we in the general public can pretty easily track most of the main points. So let's just walk through those. Remember, this started about 3 years ago, most specifically with the reopening of tumbleweed, and the county attorney was leading the charge through the first period, looking at non-conforming use and expansions and so forth. So that was a county attorney thing. P&Z then expanded those changes over the course of 2020, including, to their credit in my book, getting rid of the prohibition on the use of scientific information to modify aquifer boundaries. And there was a pile of public meetings, work sessions, and news coverage. Okay, come 2021, County Commission asked P&Z to deliver their work to date, and then proceeded to work with the planning office to develop additional modifications. The extensive P&Z changes were posted for public comments back in March, and there were lots of public input. The county cap so let's talk about lot sizes as one of them. County cap in 2011 recommended large lot sizes. The city put a specific number to that last year, arguing strongly for a 35-acre minimum. So that came from the city. Errors in the western boundary have been known for over a decade, as were documented in Laramie's 2008 cap, which is the immediate source of the line you adopted earlier this year. And that revised delineation was endorsed by 3 Wyoming registered professional geologists at the time, not including me. But the most controversial bit this time around appears to be the, quote, wastewater systems that discharge to the same aquifer that supplies a public water supply well shall provide additional treatment, unquote. And in this case, we know exactly where those specific words came from, because that's a direct quote from DEQ regulations adopted in 2016 and reinforced by a letter from DEQ to Albany County last December. So who wrote these? In terms of what we, the public, can tell, it looks like a lot of people gathering ideas and information over the last 10 years and putting specific words on paper over the last 2 or 3. And that is as it should be. You commissioners should and did gather up input and information from a bunch of sources to make regulatory decisions that we hope will prove to be in the best interests of the county. And for that, I thank you.
Thank you, Mr. Hinckley. Any other public comments? How about online? Any other public comments online? All right, the commissioners entertain a motion to close the public comment.
I move that we close the comment, the public comment. period.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Item number 5, disclosures. Commissioner Rivera,
I have none.
Commissioner Richardson,
I have none.
and none for me also. Item 6, considerations of changes to the agenda. Any changes? Yes, David, please.
I would like to request that we move item 19 and 20 up on the agenda. I do have a family thing that I would like to get to tonight. Obviously, it's up to you guys. And I'm here for whatever I need to be here for. So I would just like to make that request.
I don't have an issue with that.
Yes, you. Okay, let's do that on 8A. Do we put those 8A and 8B, please? Any other changes to the agenda? Okay. Item 7, either entertain a motion to approve the consent agenda unless you'd like to pull something else out.
I move that we approve the consent agenda.
Second.
Seconded, any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all opposed, same side. That motion carries. Item 8, the regular agenda. Present for approval amendment number 6, request to agreement with Long Building Technologies for the Albany County Building Access Control Project, and direct the chair to execute the amendment. Okay, please, floor is yours.
Yes, thank you. This is for, the value is for $15,115. And it is for a few doors and a few locks that were missed in the initial sort of review of the buildings for this lock building access project. And it just kind of, it said some additional blocks, some additional doors, and some requests that have been made in the district court for modifications. And that's about all it is. It's just for more equipment and more door locks.
What was that number again, Jake? I didn't quite catch it.
$15,115.
Actually, yeah. Commissioners, any questions?
Jake, I have a question. I correct me if I'm wrong. I thought I heard that the particular kind of lock for district court had been requested and put something different in. And so now they're having to take it out. So are we being charged for all of that?
As I understand it, there's 2 locks on 2 double doors. We called for 1 lock on one side, but not the other side. And the district court wanted it to look the same on the inside. So I don't believe we're removing anything that we put in on the one door. We're just adding additional hardware to the other door to make a match.
Okay.
Any other questions, Commissioner? I'd entertain a motion to drive number 8, please.
I move that we approve item 8 as presented.
Second,
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all opposed, same sign. That motion carries. 8A, which was the old 19, take from the table the Stone Ridge Estates subdivision permit application SD-03-21, including the preliminary and final plats. David, please, thank you.
Yeah, Mr. Chairman, Commissioners, thank you for moving those items. I appreciate that. This was, this application was tabled on October 5th. The reason was is you would ask that the applicant to work with the city to figure out the access issue. As we know, the city has applied a access policy to any roads that or accesses that come off of city roads. And so I believe you wanted to provide the applicant a little more time to do some discussions with the city. So if we untable that, then I'll give you some more information about what I've received.
Okay, and Commissioners, I entertain a motion for the old 19, the new 8A.
I move that we take from the table the Stone Ridge Estate subdivision permit application.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Old item 20, new 8B, present for reconsideration the Stone Ridge Estate subdivision permit application SD-03-21, including the preliminary and final plats. David.
All right, yeah, Mr. Chairman, Commissioners. So as I said, this was tabled, now it's untabled. So you heard this on October 5th. You do have to make a decision by Friday. I think the 19th is when the 45 days from when you receive the report on this application. What I've received since then is evidence of the applicant contacting the city of Laramie to determine what they needed to do. I've also received a letter that was provided to the applicant from Mr. Moores, who owns the property next to Imperial Heights and it borders the property that's in question here for the subdivision, and also correspondence from YDOT. Basically, that letter, and I'll sum this up, and the applicant's here and they can add all of the more information on that, but I'll just sum it up. YDOT will require that any accesses that are on this property, they'll only allow one access and will require the existing access to be moved to comply with that, to comply with their regulations, which they have distance regulations on how many access they can have. And then there was also the letter in there that Mr. Moore, who owns the property, that would not allow that to happen. So therefore, there is an easement on that property. However, they couldn't build a road there because they couldn't get access from YDOT unless that other one is abandoned. So that's one piece of information that we received. We also received a letter from the city of Laramie, and they've noted that they've been working on this project, discussing what needs to happen here. They provided two solutions that they wanted to, and you've received these correspondence, I believe, but I'll just summarize these. First, one of the options would have been to develop the ingress egress from Grand Avenue to McKinney's property on Mr. Moore's property, which has already said that he will not allow that. And that change couldn't happen because of YDOT regulations. But basically that was one of the options, is to have the county and other folks get together and develop that access. The other one is to establish, because the easement that abuts Quarter Horse, there's an easement for Mr. Couthard and Mr. Toro. Apparently there, they recommended that Mr. Couthard and Mr. Toro get an agreement with the city to connect their private road through Imperial Heights. And then Mr. McKinney, through a private agreement, could then traverse the Couthard Toro private property as well. And so that was their other option. So what we're trying to determine is whether there's sufficient access to the property. And from the information I have, I'm not sure if there's either one of these really address whether we can use quarter horse or not. And I think the city's stance is they have to have some kind of agreement, and that hasn't happened. So that's what I'll give you. I know that the applicant probably has a lot more information to provide you, and maybe there's others. But that's what I have to update you. If you have any questions for me, that's pretty much all I know.
So David, you're saying, I'm sorry.
No, go ahead, Commissioner Barrett.
Commissioner. You're saying that we are lacking one finding, and that is legal access to this.
Well,
proposed subdivision.
I'm not making a legal determination of whether access exists or not. I'm just providing you with what they provided. They may or may not have access, and I think maybe the county attorney could provide their stance on that. The whole time through with this application, I have not taken a stance on whether there is or isn't access, because I don't know. So. But it is questionable. So.
But you would agree that finding is missing.
Not that it's, well,
Because
that's a finding you would have to make. Yeah, you would have to make that access determination of whether access exists or not.
Okay.
Commissioner Ritchie?
Yeah. What happens if this commission doesn't make a decision, before 45 days is up? What does that deadline mean?
Let me pull up I believe it just means that this application will be approved.
So while you're looking that up, a secondary question that I have. See, I know that parcels aren't allowed to be subdivided unless they have access. In other words, it would be a previous mistake at the planning office if there wasn't access there. And I actually went through the trouble to, you have all those legal descriptions. I went through all of the easement or the access that was created by Warren Livestock when they sold off different pieces, and I paid attention to the I guess the primary, that's not the right word, versus secondary, rights as far as access goes. And as far as I can tell, the only thing in this situation that's holding up his ability to get access is things that he doesn't have control over, right? You can't make YDOT give you the access point that the city wants YDOT to give you. You can't make your neighbor give you access across his property when access already exists on quarter horse. And thirdly, I think that quarter horse, it's a public street. If we drove 10,000 cars through that neighborhood, which would be really mean, and we all turned around right there, that would not be illegal. It would just be distasteful. So, because it's a public street for the use of the public. So I can't figure out how the city is able to try to rope this commission in to applying their rules when no such rule exists here. And I don't even think that their rule is legal because their jurisdiction stops at their border. In other words, where the street stops, that's where their jurisdiction stops. So they, as soon as you drive off the street, well, now you're on a private road. So, you're not trespassing anywhere because I don't know how you can trespass on a public street. If you're coming the other way, how do you trespass on a public street? So in my estimation, the applicant is being held hostage in a circular, a circular sort of choke between the city and the county, and can't do anything else on his behalf, because no matter what he does, we don't consider it to be enough, or we invent roadblocks for it. And I think that it's because it doesn't matter what the aquifer protection overlay zone regulations are. The intent of a majority of this commission and of the city council is to deny him his property right, but not pay him for it, not compensate him for it, to use some sort of regulatory loophole, however thin it might be, to say you can't develop your property. And so in this particular case, the recommendation is approval, because he has satisfied all of the county's requirements. So I guess it'll be interesting to see how this commission votes, whether we can dangle ourselves on the end of a cheap legal string, to deny a subdivision that complies with all of our regulations.
Sure. And to answer your question, our regulations about the 45 days doesn't say what happens, but the statutes may, and I can look into those to see if it has anything to it. It just says you shall make it.
Yeah. So in the absence of shall, it probably means that it's like a, that it gets approved as presented. Maybe this commission will see fit to approve it with lots of, extra things added on, as opposed to letting it just time through like that. Mr. Chairman, I don't know why we have regulations if we don't follow them.
So that would be a wonderful segue.
Yeah.
Jennifer.
So to answer your questions about what's required by the regulations, the regulation requires evidence satisfactory to the board that adequate access has been provided. And then it goes on that all proposed streets comply. The letter from the city is a little misleading in that that was received on yesterday, November 15th. It talks about a county improved road intended to connect county approved road intended to connect Mr. McKinney's property to Grand Avenue that has not been built. That's never in the plat. It's recorded as an easement for ingress and egress for those property owners that were in that subdivision of lands that Warren Land and Livestock divided. And so it runs along that north boundary of Imperial Heights and the south boundary of this, but dead ends at Grand, like David was talking about. Doesn't connect to the existing access off of Grand Avenue to the Moore property. And YDOT has said that they can't get their perpendicular requirement to come into that property without expanding the easement on the Moore property. And the Moore, from the letter that we got last week, have said they're not willing to do that at this point. The other easement that serves the McKinney property that's recorded, that the easement language, which is hard to discern without a picture, but it turns between Couthard's property and McKinney's property and runs clear to the north boundary up there, and then comes down, abuts Quarter Horse Drive, and then turns and goes out towards Dwayne Toro's house, out across that other area out there. That easement as well is for the benefit of all the landowners in that area. So while the city has classified it as Couthard and Toro's road, it is also the road that McKinney has used since he bought his property and put his house out there. Because without access to Quarter Horse, his parcel is currently landlocked. He doesn't have access from anywhere else that he can get access to. And currently there is an ongoing suit, and I don't know, I believe it's still in the discovery stage, but I don't know for sure, where Mr. Toro has filed suit against the city with regard to their access policy and that right-of-way policy. And so that is in, or doesn't involve us, because it's between the city and Mr. Toro at this point, but there's no real resolution to that yet either. So I just wanted to make you aware, there are of the inconsistencies within the city's letter about whose road and what was contemplated and used as a road, as well as the existing easements that allow Mr. McKinney to access the easement that abuts Quarter Horse Drive. The city's contemplation is he can't use Quarter Horse Drive now because of this policy that they implemented in February. When we approved the Couthard subdivision in December of 2020, the finding from the board at that time was that there was satisfactory evidence that adequate access was provided without determining the legal access onto Quarter Horse because there were issues from the city at that time. Yeah. It's a legal slippery slope of sorts, but also one that when you just look at the maps, there's no gap between the easement provided for McKinney's property and Quarter Horse Drive, which is a publicly dedicated street. The contention from the city is whether or not the properties in the county have access to that publicly dedicated street without completing their right-of-way permit, which at least part of it says that if there is another legal access, that permit is automatically denied. The issue that I see from McKinney's property is currently the only access that Mr. McKinney has to his house is through Quarter Horse Drive. And that's the same access that would serve this subdivision. Because he doesn't, the easement that's granted along that south end of the McKinney property and the north end of Imperial Heights doesn't actually connect to Brand. And he doesn't have the ability to do it. If it was just say, Mr. McKinney has to pay the money and use that existing easement and do whatever YDOT requires, then that's a different scenario. He has control over all of those things. But according to the information we got from YDOT, that's not feasible within their requirements for access to the highway.
From your own office, Jennifer, you have said that this is not issue to be determined by the county.
So what the county has to determine is if there's satisfactory evidence or adequate satisfactory that there is adequate access provided. So then the question is the fact that he has an easement that abuts Quarter Horse Drive, that he's been using and other properties have been using, does that qualify, in your opinion, to be adequate access, given the city's current objections and the pending litigation, or does it not? Okay. Do you have any other questions that I can answer right now?
Yeah, just, go back to that part of this. Specifically, you're right, the county attorney has determined that the question of legal access from Quarter Horse Drive needs to be addressed by the city of Laramie and the applicant. This is not an issue that the county should decide. Do you still stand by that?
I do. I think the question of whether or not the applicant has the ability to access off of Quarter Horse Drive is one that the applicant and the city are going to have to litigate in the court system. I don't think it's one that this commission has to decide. I think adequate access, that provision in there doesn't require us to determine legal access. what I don't want is I don't want to put this commission in a place where we're saying, we've looked at all of the things and we are determining that there's legal access. I don't believe that's what this commission wants to have to do and is outside of the realm of what we're capable of doing. So then I think it's that step back to determine whether or not you believe there's adequate access to the subdivision, and whatever issues the city has with the applicant using the existing road and public road is an issue for the applicant to work out.
You know, I remember the other subdivision near this one, and the exact same advice was given by the county attorney at that time.
Yes.
That this was not a hornet's nest that we wanted to get into the middle of, to be colloquial about it. I think that was good advice then. I think this is sound advice now. So, Commissioner Richardson?
Yeah, it's kind of interesting to me. We haven't spoken about, I'm using the wrong terminology, but there's like primary and secondary, or
Dominant and subservient.
dominant and subservient access. And maybe the applicant's attorney can speak to that. In my mind, even though it's not something we have to decide, I think it's an issue germane to this commission, and that is Warren Livestock used to own everything up to Highway 30, you know. So the entire subdivision of Imperial Heights was Warren Livestock land, and every single subdivision east of Grand Avenue out there was Warren Livestock land. And they sort of had boilerplate language, and every single subdivision, when they created it, they preserved the right to go through the subdivision to access the larger ranch behind it. And that isn't limited to Sherman Hills or any of the others. It's, you know, Imperial Heights is one and that's basically the documentation that the applicant provided. And in that particular subdivision, I don't really understand the city's assertion that this particular landowner doesn't have access when that easement or that was required or allowed, or sort of for every single parcel in the subdivision. So I don't really understand how you say, well, all the rest of them in the subdivision have that, but this one doesn't. Also, so in that vein, if he has access to use the private shared driveway or road that is, you know, the county end of Quarter Horse, then the only limitation is the imaginary line, you know, or the very thin line. It's not imaginary, it's just not visible. The invisible line that, you know, where you cross over from across into the city's boundary, right? And it's my understanding, the way I read these, that to that subdivision, both rights of way or both easements exist. In other words, one isn't preferential to the other, maybe unless the city decides it is. But codified in the deeds, I think what I read was that they have two equal accesses. One is through the Imperial Heights subdivision and Quarter Horse itself, and the other one would be, you know, along the north edge of that subdivision. So I'm not sure that anyone can give either one, you know, like we can't decide because we feel like it, that one of those has more value or more preference in the law than the other, the way they're described on the deeds. In other words, they have two ways to get out of their subdivision. By that, I mean more Toros, Scazafava, you know.
The six.
Yeah, all of those. Whether they've developed the other one that someone would rather they use or not, it doesn't preclude them from using the one that they already have. So from my perspective, I am satisfied that not only is there legal access, there's more than one legal access. One is developed, one isn't. And we can't adopt or try to apply the city's whatever they have going on there. That's something that they have to do themselves.
The distinction I would make in what you said is that the easements that are recorded for these properties don't go from what we have in front of us, don't go into the Imperial Heights subdivision, they abut it. But it is drawn on the easement. That easement comes down around the corner of the piece, past or to the edge of that Quarter Horse Drive. And the easement on the bottom, which abuts the Sherman Hills subdivision, which is on the far south end of this, runs along that south side, and then it turns up until that easement comes abuts Morgan Drive on the other end. So I think there's an inference to be made that the intention was that both Quarter Horse and Morgan could be utilized when those easements were put into place.
So are you saying that the easement goes up to the line but doesn't include it? Like there's this impossibly infinitely thin line there that the easement stops at to make you not be able to cross onto the city street?
Like all property lines, right? It's described so that it runs along that same line as the Quarter Horse Road, public road, and Morgan on the bottom.
I mean, is there ever any situation where somebody describes an easement up to land that they sold off, like in the case of Warren Livestock, and it's, you know, it doesn't matter how thin the line is. The question is the line included or not included, right? Is there a wafer thin border that you can't, barrier force field legally that you can't go through?
And I don't mean to speak for Megan. She can certainly speak for herself. I think what the applicant is saying, where that line abuts a public street that's dedicated to the public in a plat that's recorded, then the applicant's contention is that they do have access to the street. The city's contention is they do not.
I don't understand how you
We're, Mr. McKinney and the city are at a stalemate. However, I believe that Mr. McKinney has not showed or come forward with legal access as our regulations require. And I have my opinion, you have your opinion, Heber, as does Commissioner Gosar. But I can't ignore previous legal advice to you before I was on this commission and the one that we're receiving now, which are in agreement that this isn't a hornet's nest we want to go into. And I do not want to settle this for the city. This is their fight to
And
previous and all. So
I agree with you 100%, which is why we should approve it and then let that disagreement with the city isn't ours, it's the city's. And so that would be between the applicant and the city. I think that you've drawn the wrong conclusion. The right conclusion is that we approve the subdivision because it's satisfied ours. We don't have anything in our regulations that points to us defending the city's, they have their lane and we have ours, and when ours is satisfied, then the applicant has to satisfy the city's lane.
but it hasn't been satisfied.
And
there
that-
isn't legal access.
Right, but that's not for us to consider.
But it's not for us to approve when it is one of our findings and conclusions of law that is required.
Would the applicant like to address, you don't have to, Megan, but it seems like it might be helpful. You can shed some light.
Sure. My name is Megan Getz. I'm attorney for the applicant. I would contend first, Commissioner Ibarra, that we have satisfied by your commission standards, which is adequate access. If a landowner can't come before the county with an easement that is more than a decade old that shows how he or she has accessed his property for 10 years, to then have the city come in with a policy, not even a law or a regulation, but to say, oh, now we're kind of questioning whether we can do this. And for the county to then interpret, just as your attorney advised you not to say, now we don't have findings that we have legal access, is not only materially an error in the law, but it's arbitrary and capricious by the commission. We've come forward and we've said, here is a legally recorded easement that shows how this applicant can access his property. The city is saying that that doesn't meet our right-of-way policy. In fact, the city's own policy actually says if there is a legally recorded easement, our policy doesn't trump that. So part of the discussion with the city is that there is a legally recorded easement that doesn't even put a potential right-of-way policy into place. So we have met all of the county's standards and conditions. If you're going to change and interpret what your condition says, that now we have to demonstrate legal access to everyone in the world who doesn't even have a jurisdictional argument to contest access, that is, I would argue, a very slippery slope and a legal standard that will put this commission and future decisions very much in jeopardy. You have already made the decision that that access, Quarter Horse Drive through that easement it meets your standard. You've already made that decision when this commission approved Mr. Futhard's subdivision. You made the determination that access was adequate under your standards. So to now go and say to just a neighboring landowner, nope, never mind, we actually prefer that you enter through Grand Avenue, that's arbitrary and capricious. That is making a determination that is not consistent between two landowners who you've already said that proposal and that applicant had adequate access.
So then I would argue, excuse me, go ahead.
Oh, go ahead.
I would argue, had I been on the commission at that time, that would not have been approved for the same reason that it didn't have legal access.
And with all due respect, Commissioner Ibarra, that is why the county has regulations. So that whoever the commissioners are that are in place, they follow the regulations. And there's been no argument that the commissioners didn't follow the regulations of the county. If the county wants to change the regulations to say legal access must be determined, or we are going to, by law, adopt every policy as our own that the city of Laramie puts into place, then the commission can do that. And those are the playing rules that Mr. McKinney and every other applicant has to comply and abide by. But what he has done is he has met every condition and qualification that the county rules and regulations set forward. And to say now that adequate access by a legally recorded easement does not meet your conditions, we argue it's arbitrary and capricious. We have tried to come up with an agreement with the city as you directed us to. We tried even before you sent us back. And I think the letter that the city has provided emphasizes the level of frustration and hand-locking that Mr. McKinney has felt throughout this entire process. He has tried to be a good neighbor and he has tried to play by the rules. And the city has said, we can't even impose our rules on Mr. McKinney. We don't know what to do. In the letter, it says, our hands are tied. We've met a wall. We've hit a wall. Well, you cannot have property subdivision rules and regulations that are governed by whether or not we've hit a wall. We've either met the regulations and requirements or we haven't. And to create a finding now that legal access through Mr. McKinney providing the county a copy of that easement is insufficient, is legally incorrect and wrong. So we will take this up with the city. If the city chooses, as it's threatened, to impose concrete barricades to all of the people that access their property off of Quarter Horse Drive and any other city street that goes into county territory, if the city wants to put up concrete barricades like they've threatened, we'll deal with that. We'll figure that out with the city. But if the county truly wants to follow its attorney's advice, it needs to approve this subdivision so that we can go and have that discussion. To deny it is going to put you in the exact same position as the city. You will then become the city and you will be imposing and regulating the rules of the city. And by rules, I mean policy. This isn't even codified regulation. This does not, by the Wyoming Supreme Court, have the effect of a rule. So I know I'm being very strident, but this is very frustrating to an applicant who has exceeded all of the requirements and done everything that you've even asked him to do that goes beyond that. And then to come back and say, well, we're still not sure because we don't know what the city wants, is like for me to say, well, I'm not sure what Wyoming should do because I'm not sure what Colorado wants. It's jurisdictionally inappropriate. So we'd ask you to approve the subdivision. I can certainly stand for any questions.
Sure, I have a few. The city has a right to that street, is that correct? So they have jurisdiction to that quarter horse, is that correct?
Quarter Horse Road is a publicly dedicated right of way.
Who has control of that road? Is that a county road or a city street?
Quarter Horse is a city street because
Okay, so-
Imperial Heights is a publicly dedicated subdivision.
Right, so that's out of our jurisdiction, right? So if this were a county road, then we wouldn't be talking about the city, we'd be talking a whole different amount and different level of impact. That does not belong to the county. So I might disagree with your analogy about what happens in Colorado doesn't affect what happens in Wyoming. Well, it would if Colorado owned a street in Wyoming. And so we have to worry about the rights of other entities. Now, legal access and adequate access, that sounds like a court's determination to me. I don't feel particularly able to determine legal adequate access. And I do feel sympathy towards Mr. McKinney. I do. I think he's in a tough spot here. Right? He has an easement through a property that YDOT says is not useful, and the property owner says, well, I'm not going to change that easement. How is that different than where we set up against, right? So YDOT said we have to meet these rules and regulations. The property owner says you don't meet them, and I'm not going to give you a different easement. City says you have these rules and regulations. We're not going to change them. How is that different for us? What standing would we have to say to the city, well, we just disagree with your use of your street? How would you answer that question?
This commission is charged with making a determination as to whether or not Mr. McKinney has met the Albany County rules and regulations as it relates to a proposal for subdivision. There isn't one rule that he hasn't met. I get that perhaps the county and the city want to talk about what's good for county roads moving into the future, but you can't hold Mr. McKinney hostage to a policy that the county isn't even a part of. It's absolutely different in that there is a legally recorded access. If Mr. McKinney didn't have an easement, right, and had just been using Quarter Horse Drive and with the grace of his neighbors saying, yep, you can cross my property, that's a very different situation. But we have a decade-old 2010 easement that says you are entitled to come up to Quarter Horse Drive. Quarter Horse Drive is a publicly dedicated right-of-way. It would be the exact same scenario if I came out of this courthouse and somebody said to me, oh, you're leaving the county building. Now, before you can turn left on Ivinson, we're going to check with the city to see if you have permission to do that. It's, as your attorney has already explained, legal boundaries come up to the point of which the property description ends. They don't go through it. They don't go beyond it. It's a meets and bounds. It's how Wyoming real property has been governed for, of course, centuries and ages. So I appreciate that this commission doesn't want to get into whether or not Quarter Horse Drive can be monitored and modified by the city. In fact, whether any public right-of-way can be monitored and modified by the city. But what it is within your purview is to say, under our rules and regulations, Mr. McKinney has provided legally recorded access through a grant of easement. That's adequate. Mr. McKinney has complied with all of the other requirements as far as the subdivision and gone above and beyond that. And that meets our rules and regulations. If the city wants to come in and restrict Mr. McKinney's use of Quarter Horse Drive, that's for the city to do, not for this body.
Well, I would argue that the easement, like all property in Wyoming, there is a line, right? I cannot corner hop from a piece of public land to another piece of public land because it's not allowed, right? So there is a line. And so that easement stops at a line, somewhere where we lose jurisdiction. The city has jurisdiction. And I don't particularly feel, I'm kind of with Mr. Richardson, and when he says we should stay in our lane, I don't feel like I should tell the city what to do with theirs. But I don't like them telling me what to do with the county. And so how would you answer that? That easement you feel legally allows Mr. McKinney to go onto corridors and build a subdivision with that legal access. You believe that? You
Yes.
believe- okay. And what would you point to as your authority on that thing?
The legally recorded easement. The easement which describes that was in place that said he can access his property from Quarter Horse Drive. If the city is now 10 years later saying, nope, you can't use our publicly dedicated rights of way to access your property, that is for the city to impose. That is not for the county to become a participant.
Well, I think we've become a participant. And maybe there's no good reason, good way for us to not be a participant one way or the other, quite honestly. So I think that if we approve, we'll be a participant in a legal action. If we don't approve, we'll be a participant in a legal action. So I don't know that I feel particularly compelled by being part of a legal action by whatever decision we make. It's an interesting conversation, and I do have some sympathy for your applicant, for the person you represent. Anybody else have anything?
Mr. Chairman.
Sure.
What the city is doing by trying to restrict traffic on its street isn't legal. Of course, that's not something for us, to consider, right? If you have a licensed, registered, insured car, you can drive on any city street without restriction unless they put up cones, block it off for construction. The reason that we approved Couthard's subdivision is so that we would stay out of legal action, and we have. Your assertion that that we'll be in legal action if we don't approve it, and if we do, we'll be in legal action if we don't approve it. We will not be in legal action if we do, because the city doesn't have any standing. There's no one who has standing to come after us for following our regulations, for doing our job. So if we don't approve it, we will be in legal action and we will lose. If we do approve it, there won't be any legal action because no one has any standing, or if they try, it would be dismissed before any arguments were heard. It could just be summary judgment, which gone.
That may or may not be the
I
case.
feel like I'm stuck in an Abbott and Costello routine. I'm pretty embarrassed. I'd just like to make a motion
Okay.
and go.
Commissioner Rivera, do you have any other?
I'll let you make this motion, but I then have a question for
Okay,
either David or Jen.
go ahead, Commissioner Richardson.
Mr. Chairman, I move that we approve Stone Ridge Estates subdivision permit application SD 0321, including the preliminary and final plats, incorporating the findings of fact and conclusions of law, and not our feelings.
Interesting motion. The move, is there a second? I'll second that motion dies for lack of a second. Commissioner Rivera.
Yeah, David or Jennifer, David, you brought up that on Friday, we have to have some kind of decision. Can one of those decisions be that is be continued, that Mr. McKinney continue to look at his options as far as working with the city? He has the option of approaching Mr. Moore and working something out with him, whether it's paying him for access, whatever, or by making a motion or approving a motion to continue. Is that a decision that can be made without approving, meaning it doesn't automatically approve the subdivision application?
To me, my interpretation of what, so I looked at the statutes and they're not any clearer than our regulations on what has to happen. But to me, a decision is a yes or a no. I mean, that's what
Need
I
a
would,
deny or
yes, deny or.
is that your interpretation, Jennifer?
It is. I think it could be approved with conditions, however, like we have done in other subdivisions. It could be approved contingent on them securing access through Quarter Horse Drive from the city.
And can that be furthered by a contingent on securing access by a certain amount of time? Can there be other conditions on that?
I think that is not unreasonable. But I think it has to be,
Jennifer,
yes,
how could we make our approval contingent on the city when their policy is an administrative policy that's not codified? And when the deed, the easement described in the deed predates any policy that the city might have. I mean,
One question at a time for Jennifer.
well,
So
she can entertain it. The point is that I don't see any way that the city can make a policy that trumps, that supersedes the access described in the deed when the subdivision was created.
and I think where we're stuck here is Mr. McKinney started his subdivision process, working with the DEQ, getting plats, doing all of those things long before the city implemented their policy. But also, his permit application wasn't submitted until after. But then after his application was submitted, we have the Toro lawsuit with the city pending this exact issue, has no resolution. So it is a better decision for this commission to make a finding of yes or no, and know that a lot of this hinges on a decision out of district court with regard to the Toro decision. And however that ends up being structured, and then it may, if it's appealed, depending on the outcome of Toro, be reversed by the court and would then be subject to being granted. If that access were, if the district court were to determine that these properties have access via their existing easements over Quarter Horse Drive, then it would be remanded potentially back to this court or back to this commission for modification based on that decision.
Jennifer, based on legal position of which of those cases would you rather represent? The city's case or the plaintiff's case?
I don't get to make policy. I just give you opinions.
No, I asked you an
You get to
opinion.
decide what you want.
I asked you an opinion,
Okay. Anybody else
not a policy
like to speak on this
recommendation.
behalf? Okay. I'd entertain a motion. Would you like to, if Mr.
I
McKinney would
just
like
wanted
to
to see if Mr. McKinney wanted to speak, if you, maybe even to what Jennifer just addressed.
Commissioners, Marty McKinney. I've sat through this and I'm really trying to stay calm and keep my blood pressure down. And, the thing that gets to me is the fact that I don't have access anywhere else, right? I don't have it off of Grand Avenue where the city seems to think that we have other access. I know you asked, and so did the letter from the city that, can we meet with Sean Moore? Mr. Moore that owns the other access to see if he will grant us other easements or accesses or whatever. And he's unwilling to do that. that was one of the things we met with the city about last week for an extended period of time, and that's what they wanted us to do. And I was like, it's not going to happen. You know, I mean, I don't know, you're just gonna have to take my word for it. I mean, you can call and ask him, but I promise you, that's not something that he wants to do. Hence the letter he already provided us said, I'm not doing that. You know, I'm not doing anything that, you know, that YDOT needs. I'm not granting you additional easements. I'm not, you know, getting rid of, you know, there's already an access easement for Old Quarry Road. He's not getting rid of that. You know, that's the city's easement to access the water towers on top of the property. You know, so why would they want to get rid of their own easement? That, you know, it doesn't make any sense, right? So the only access I have is off the courthouse. There's no other legal access for me to get there to my property. Even without the subdivision, there's still no other legal access for me to get there. So, you know, the frustrating thing for me is Quarter Horse is a public street. It's not owned by the city. Okay, the city is a steward, okay, and they're supposed to take care of the street. So for them to come to me and say that as someone who owns multiple properties inside the city limits, right, and licensed vehicles, and pay my taxes on time, and do everything that I'm supposed to do, you know, now the city's telling me that I can't drive off the end of my public street, right? I own that public street just like everyone in this room owns Quarter Horse. Okay, we own it because we're the public and it is a public street. Like Heber said, we could drive 10,000 cars on that street and there's nothing the city can do, right? That is my big problem with the city. Then they ask us to provide a bunch of information to them and they don't get back to us. And when they do get back to us, it's some vague little letter that we sat down and I already told them is not going to work. They're like, well, maybe we should talk to Sean Moore and the county and the city and all of us get together and cost you, the county commissioners, money, right? Is what it says in the thing, so we can all fit the bill together, right? And maybe YDOT and Sean will then join the group. I'm pretty sure that the county doesn't have a lot of extra money laying around that they want to donate to this cause, right? You're donating enough time and money right now, over an hour so far to this cause just today, right? I don't want to pay any extra money. I've already paid money to develop a street and a road that goes all the way to my property. I have, you know, money on the table already with you guys to put in another road out there. Mr. Kuthar is not going to put up more money to build an additional road. Neither is Mr. Tor. You know, so it's just super frustrating to me that we keep going over this thing about who has jurisdiction, right? It's you guys have the jurisdiction in the county, right where the line stops. Great. My line doesn't stop there. Your line, because I have access to the county from Mr. Toro, Mr. Kuthar. My line doesn't stop because the city road it's not a city road, it's a public road. And I think that's where people are getting a little confused. It's public. Me as the public can drive off of the end of Quarter Horse because I own that road. Just like I own the easement that's there and I have the access from Mr. Toro, Mr. Kuthar to get to my home, right? So it's not a city road. And the fact that the city says, comes up with a policy in January, okay, which Megan has already told you, policy is not law, okay? In the Wyoming Supreme Court, policy is not law. So for them to adopt some little piece of paper that all of a sudden says now, after 10 years of us accessing our properties, we can't, doesn't make any sense. Doesn't make any sense to me that we're having this discussion in here, right? I mean, if it's a public street and I have access off the end of the public street, it works. You know, Mr. Gosar just said, oh, well, we can't corner jump, right? Well, if I have access on this corner and access on this corner, but I don't on these two corners, I can't jump that. Exactly what you said, right? And I agree with you 100%. But if I have access on the road here, because it's a public street, and I have access that butts to it, not corner jumps, but butts to it, I still have access. I don't understand it's frustrating to me because I don't understand why we're talking about it. You know, and I've been dealing with it for an enormous amount of time and an enormous amount of money. I mean, when I started this entire process, I went to the city 2.5 years ago. to find out what they wanted in my plat, in my subdivision. I didn't have to, but I did, right? Because I'm trying to work with the city. They give me some stuff, I put it in there, city's okay. In fact, the city tried to buy my lots from me at one point, okay? So that no one could build on top of the aquifer, because that was kind of a thing for them. I said, I entertained that. I took an entire year, and this is why we're here now, because I waited an entire year trying to work with the city so that they could purchase my land. We didn't come to an agreement, okay? Got a letter from the city attorney, or from the, from Jordan, that said, we will not, there's no ill will. We will not do anything to hamper Mr. McKinney's ability to do a subdivision. That seems, creating a policy for access to me seems a little weird, that we're not gonna create any problems for Mr. McKinney, but now all of a sudden there's a policy. They sent me a letter that says I don't have access. The first thing I did, I go talk to them, right? The first thing my neighbors do, hire attorneys and sue them. I've met with the city. Before we came here last time, I met with the city, sat down with Jeannie Jordan, the head utility guy, and said, look, what do you want from me? And they were like, well, you don't really butt into the city, so it's between them. I said, well, here's the deal. Give me what you want, City of Laramie. I will take it to them and present it and try to be the middleman and do everything that the city wants. Okay? It has been more than 12 weeks as of last week on Wednesday when we met with the city. And you know what the city gave me in response to that conversation? Nothing. So you want us to go and work with the city. I have worked with the city and worked with the city and worked with the city, and I have nothing. I get this little letter that says, well, let's try to spend everyone else's money, number one, on an access that YDOT says we don't have. Or two, let's get with Mr. Kuthar and Mr. Toro and see if we can come to a resolution. Well, we already know the resolution because Mr. Kuthar or Mr. Toro is in litigation with them as we speak. On policy, right? The whole thing is over policy, which again, policy is not law. So that I don't see any way that the county is, or the city is going to win that lawsuit, right? And I ask you guys, to look at it and go, you know what? The guy has spent an enormous amount of time and money trying to work with the city, and the city has done nothing for me. Okay? It's caused me problems the entire time, and I've done nothing but try to be good to them, help them out, do whatever they wanted me to do. And here I am still dealing with a city matter standing in front of the county commissioners. So I urge you to kind of look back at it and say, hey, this isn't a matter for the county. This is a matter with the city and Mr. McKinney. If it becomes that far, it has nothing to do with the county commissioners. Thank you. Do you have any questions for me?
Any questions? Thank you, Mr. McKinney. You entertain a motion, commissioners?
Mr. Chairman.
Yep.
I move that we approve the Stone Ridge Estate subdivision permit application SD 0321, including the preliminary and final plats, incorporating the findings of fact and conclusions of law and not our feelings.
We could do that. It's the same motion. But is there a second?
There's a second.
Okay, I'd entertain a motion. Another motion, please.
You are right, Mr. King. This isn't a decision that needs to be made by, as far as your access and all, by this commission. That's between you and the city. And I appreciate everything you did and the length of time that you had to deal with things and all. I told myself I wasn't going to do this, but I would be willing to make a motion to approve Mr. McKinney's application contingent on that being settled between you and the city as far as proper access, and not until you have that worked out with the city. I'm not going to commit this commission to making that decision anyway, but I'm willing to approve the subdivision contingent on that requirement.
For a second.
Yeah, but I think you have to incorporate findings of fact and conclusions of law, and then.
Even though what is there.
Yeah.
But it
Interesting
is.
position.
But it is. Well, you can't make a motion without incorporating the findings of fact and conclusions of law. That's the whole reason that we're here, right? If we're gonna approve something without the findings of fact and conclusions of law, then we're approving it on our feelings. That's the only basis we have that we can defend in a court of law.
But you can, according to our legal document here, that you can approve it contingent. Says approve with the following contingencies. So you can approve the option number 2, the subdivision permit, including the preliminary and final plat with the following contingencies. That seems to be an option.
Well, and I think those aren't mutually exclusive. You can include the contingency but you still have to incorporate the findings of fact and conclusions of law, because there's a whole bunch of other ones that are still there.
Okay, so I move to approve this subdivision application, considering all findings of fact and conclusions of law contingent on the requirement that Mr. McKinney secure adequate and legal access from the city to this subdivision.
Second.
Moved and seconded. Any further discussion? Well, I'll just have to put my 2 cents in. I'm going to vote against this motion because there is a court going to decide this. And I think this is where that decision should be taken care of, not on this dais. So any other thoughts? The moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
All opposed, same sign. Aye. That motion carries. Thank you for the lively discussion. I appreciate it. Thank you. All right, back to number 9. Discuss concerns about road maintenance and ingress egress at the paddocks at Fort Sanders. Mr. Garcia, is there Mr. Garcia here?
I am here.
Thank you, sir. Thanks.
How are you guys today?
Doing all right. Thanks for
So, my name is Mark Garcia. I live at the paddocks at Fort Sanders. We have a, we'll take very much of your time. I want to show a document that it's a traffic study that was done by Research and Development back in 2019 for the paddocks. And we'll give it to you.
Okay, good. Please, thank you.
If you'd like, I could email it to you because I do have it. What we're trying to, what our main purpose here today is to ask the commissioners that if any other development is going to be done at the paddocks, that some of the findings we have found that are inadequate to fire hydrant, road maintenance, egress, be addressed before any other plots are done. I'm going to turn it over to Mr. Katz. He has the some of the findings that we have. You can state that you guys were emailed, check, you were emailed on those. So, Mr. Katz.
Commissioners, my name is Cy Cass, and I'm 809 Rampart. I'm here today trying to talk about egress, ingress, fire response for our citizens at the paddocks. When I moved out there, we had access onto County Road 22 when I purchased my property, and then shortly thereafter, both those accesses were gated off. These were installed and they were gated off to us. Both those accesses, one is on Post Road and the other is on Traverse Road. And then City Ranch Road was improved, and now that's our primary ingress and egress for the properties that are in. What I'm here to do is kind of shed a little light. I have a little history in fire service in fire code. So my stance with this, and what I'm trying to get us is some better access for the paddocks, not only for a fire response, and that's kind of what I'm leaning on is the IFC. I believe we've given you some examples. The 2018 IFC International Fire Code shows the main requirements. I'm full understanding that the county has not adopted the fire code. I know that's the stand. So I have gone to the fire board. I've asked for their support on this as well. The history behind this, I've tried to dig in and see how this all happened in the first place. Because at one point, those accesses were open on County Road 22, and then phase 2 of the paddocks was opened, and all of a sudden there's a brand new road in there that was not in the original plans, and then we closed 2 accesses. So it went from 2 to 1, and then added more residences, which is against the fire code. The fire code clearly states 30 dwellings needs at least 2 accesses with separate roads in them, because when bad things happen, bad things really happen when you limit the egress of the citizens. And it's not just for me getting fire trucks into this place. That is an issue to me, the way the landowner has described that there was an agreement that we can just show up in a fire truck and cut a lock to get into a house that's burning or somebody not breathing. That was the understanding, and that was what he said was okayed at the time by those that approved it, which I had a hard time figuring out who that actually was, whether it went through the fire board in some agreement with County Road 22 and the access is up there. I'm not sure. We can't really find that stuff. We've asked him to enlighten us on how this became an issue in the beginning, and he hasn't been very forthcoming with how that happened. So I'm going down the route I know, which is the fire code. So I went to the fire board. They didn't really have a good answer other than they were not in favor of this. They weren't in favor of those accesses being closed off. And then I went and talked to Chief Young over at the State Fire Marshal's office, who's the Assistant Fire Marshal, because I was kind of at a loss. We don't have International Fire Code adopted by the county here. So then it falls over to the state. So I called him and said, hey, Chief Young, my understanding is where we are lacking in code, we rely and fall back on the state, which he said, yes, that's true. The problem is he does not himself have the authority to impose those on residential areas. He said, I can come over as the state and impose these codes where they're lacking from the county on public businesses, things of that nature. So we kind of find ourselves in a little sticky spot.
So only commercial, not
That's what he has the ability to come over as the state fire marshal and impose. So I said, what do I do? Jokingly, he said, keep a bolt cutter in your car, which, you know, we found, yeah. Anyway, and not to throw him under the bus, he was doing me a solid. So he said, honestly, go back to your fire board and then obviously come back to the commission. So kind of, this is where we come back to, is we're asking you to help us with our situation. The code's there, it's simple, it reads very clearly what's supposed to happen. It also reads very clearly if these accesses are denied to us, the improvements to the road, the changes in the road and all this stuff. And that's in our current state. We have, let's see, as of 11/16/21, there are 41 structures that are built out there that have access off of what we're saying City Ranch Road. The total build out of this thing is looking at about 225. The way he has this structured, it's pretty interesting what we're going to try to do to get people in and out of here on a daily basis, rather than emergency service being able to come out and do that in an efficient manner. I can attest over and over that time does matter when it comes to these instances, whether it's fire or medical. The way we're set up right now with grass fire, and we brought this up in the HOA and he was there, and I tried to explain this stuff to him that, you know, if there were a grass fire right now that was coming in that ingress, so City Ranch Road, there's no place for people to evacuate to. We would have to drive through barricaded metal bars to try and stay safe, basically. So We did have some issues with fire hydrants. When things were put in, the fire hydrants were spaced rather far apart. I do know, working and giving fire support to the county for over 21, we're up to almost 21 years now. Our water is very limited in the county. We're pretty precious to have what hydrants we do have in there right now. His second phase of this subdivision actually followed the IFC code as far as what fire hydrant spacing is. So phase 2 actually looks really good out there. It's really nice. We only have 3 hydrants that cover a lot of what our homes right now in there. And that is one of the issues we brought up to him, and we were trying to remedy as well too, that all of our homes are built up to code. The International Building Code, Electrical Code, is in our HOAs, that we follow all these codes. Those all go hand in hand with the IFC. They're all through the same regulatory service. So the fact that we have to follow our homes were built, everything else is built up to this, just kind of left out the whole access thing. And I know the can of worms that this is open. I know County Road 22 has its issues. We are not allowed to approach, I don't even know how to put this. Through our HOA, we're not allowed to inquire on our own about that access.
To Mountain Cement.
Yes, sir. So that's our other reason why we come before you today. Apparently, we need to ask you for help. And that's what we're doing today. Are there any questions other than, I mean, the code's in front of you, you can read the code, it's pretty clear. What that is, it's the interpretation of how do we employ what the state has adopted for fire code, how it applies to our current situation, and how we can persuade the right people to do the right thing.
So Mr. Gass, I just want to make sure I understand your ask. Your ask would be somehow enforce IFC 2018 into the first phase of the paddocks and or spacing in the phase 1 development of the paddocks. Is that, or
That is, we're asking to follow at least the code. So the code says 2 entrances. So we have City Ranch Road, and to follow the code specifically, you would only have to allow us access through one of those gates. To follow the code specifically, I'm not going to ask for more than what the code states. But yeah, it would be nice to have the choice of which gates those were, and actually have both gates open that were originally plotted for phase 1 and used until they changed and opened this phase 2, where those were blocked off and City Ranch Road was taken over.
I could have swore we had a conversation about this early on in my career here about a lot of getting paddocks. I can't recall that. But
Mitch Edward is on the line and represents Mountain Cement. If you have questions about Mountain Cement's use of the road and the history behind that, he may be able to give you some insight.
So is it my understanding that County Road 22 is still a county road, not owned by or Mountain Cement?
It is not a dedicated county road.
So why is it considered a county road by the state?
I can't answer that for you.
I know lots and lots and lots of information about this.
I have a map here, if you guys would like to see it. I mean, this is John's.
And I'm familiar with it.
Are you familiar with
Totally.
it?
Yeah, I know every
Okay.
square inch. I have some observations. The reason that the builders and the homeowners have to do IBC and all that kind of stuff is because that's a homeowner cost. The reason that was left out of the developer's side is because that would have been a developer cost. So if you're trying to figure out why you have a developer who set up the association or the homeowners association, as much burden as was possible was put on the homeowners, and as little burden as possible was put on the developer, right? The developer actually owns the gates. And the reason the developer has the gates up is because the developer doesn't have legal access to Howe Road. Howe Road, I don't know why it has a county number. Probably because at some point it got a county number, you know, but it was built by Mountain Cement for Mountain Cement traffic, you know, down from their quarries, and it's still maintained by Mountain Cement. County doesn't spend any money to maintain that road.
So was it,
Can
was
you help me
the
with
agree-
phase one then? I mean, the first access is,
I think that at the time, and Mitch will probably be able to clarify this, but I think that at the time that was in dispute. And so since that was the access, that was the access. And then at some point, it was decided legally, you know, that he couldn't use that as an access. So then he had to create a different access for his subdivision. It's a matter of diligence from the beginning on the developer's part, right? But if he says you can bash through his gate like the Dukes of Hazzard, you can bash through his gate like the Dukes of Hazzard. He gave you permission. You know,
true.
it may not be ideal, but it's an extra mile down to City Ranch Road and an extra mile back. So if you were at that first house in there, it'd be a 2-mile round trip. You could probably get through the gate faster. I'm not saying that that's ideal or anything.
Yeah.
I'm just,
And that's why the fire code exists, because that's not an acceptable
right.
choice for
Well, and at the
emergency
time,
services to do that. So
at the time, and when that subdivision was approved, and I wasn't a commissioner then, but those entrances were open. It was later decided that they couldn't be. So this issue developed after that subdivision had been approved.
And part of the reasoning behind that, if I'm only speaking on this, was when Neptune and Cement could not come to agreement as far as road maintenance off of Howe Road.
Yeah,
That's when he decided, he came to commission and they said, we will grant you access off of City Ranch Road, but there was an agreement, if I'm not mistaken, that had to be paid.
yes.
Now, on the other
And
hand,
that predated,
correct, on the
Yeah.
other hand, the only way we could access Howell Road until YDOT created a turn lane off the City Ranch Road. So basically, he went a roundabout way to do it the cheapest way he could, but still only granted paddocks one ingress with less than 30 houses until what the fire code was saying, other than what they're recommending was 30 or more, 2.
yeah, and
I know this is a sticky one.
well, the
But we're
sticky
looking
part,
at, honestly,
the sticky part is that, you know, that's South Laramie water, so it's a special water district, you know, with all the pressure and flow that you need. You could probably go, I mean, I'm not a civil engineer, but you could probably go back and retroactively install fire hydrants
yes.
more at more frequent intervals and deal with that
Use in
issue.
place. So yeah, that's an absolute possibility to do that without issue.
I mean, I don't know how it was designed, but I'm gonna guess that you don't hardly ever open 5 fire hydrants in a series. You know, maybe 1 or 2
Right.
or 3,
It's
so.
about, and
the
the
further-
reason spacing is for access to the structure and friction
Sure.
also within the hoses, and there goes into.
But the point is you wouldn't overtax the flow of the system by adding more hydrants
No.
because you aren't likely to.
No, the spacing is directly for being able to pull.
So I wonder if the developer would be willing to go and do that on his own.
Didn't sound like it.
Right. So what's interesting about this is that it's sort of an ask to the commissioners that we see. What Mark asked is that we don't approve any further subdivisions, you know, or further phases of the paddocks until the issue is dealt with.
correct.
But I don't know that we can even do that unless our regulations, we have to have something codified that we can cite, like the International
And
Fire
that's why I
Code,
threw
right?
that to you. It's something you can stand on, and obviously the state of Wyoming
Sure,
is there. They can enforce it, but they said, come back to you. It's there. So they've adopted it. It's something that you can use because you haven't adopted it here. I'm not asking you to go adopt the fire code right now. But the state has that in place.
Sure.
You can use them as a reference.
I was thinking that you were referring to commercial development only, not residential.
No, our residential. I'm looking strictly at our access for the safety and well-being of the residents of the paddocks.
So what really needs to happen is the developer, if they're not allowed to put cars out on that road, the developer needs to put an automatic, siren whoop gate or something on there so that emergency services can get through it, even if everyday traffic can't get through it.
And I'm asking for egress as well for our citizens that live out there. Because if you have a fast-moving grass fire, which we have some winds known to blow around here and can create some rather hazardous conditions for us, it's almost near impossible for somebody, or I would not suggest anybody drive their vehicle through a 10-foot wall of fire to try and get away from it. That is the situation, other than turning around and, like you said, busting through.
Sure.
So pick or choose, I guess. Either way is not really good options for us. The one gate that seems to make the most sense right now is the Traverse Road, because that access is open onto Peachtree County Road 22, but I guess Howe Road. That one's open to the road. There's access for, the other Barricade Road and I guess Garrison itself for the structures that's up there. If that were open and meet fire code, and it's already got access to Howe Road. So I guess we're asking for a little help.
Yeah, it's really interesting. I never understood how he got in his first phase. He got Cavalry Row to be able to access Howe Road, but none of the rest of the first phase.
Well, he actually got Garrison also, but I think Garrison is grandfather closed in because of the ranch that sits out there. So Garrison is still open, and so is. Yeah, I hear you.
Yeah. Only Mitch knows the answer, I think.
Which we haven't got to hear from them. We don't, the public, we haven't got to hear.
Megan gets would also like to speak.
Yeah, I saw Megan's hand up. Yep. Okay, guys, I appreciate it. I mean, I gotta tell you, we're probably not gonna do anything about this tonight, even if we wanted to. But it'd be nice thanks for bringing it to our attention. I'll have to go back to my notes because I think we visited this early on in my tenure. And there was supposed to be some blocks being removed from the gates, if I remember correctly, but maybe not. So I'll have to go revisit my notes.
Yeah, and I think the biggest thing that we're speaking about, like I speak with some of the other parents, is that we like notification when John does decide to, or Neptune, I should say, wants to develop more out there without these issues. If you guys get a chance, run out there and see what we're talking about. I mean, physically go out there, look at the roads. And like if the state adopts an MOU, we have an MOU, and I hate to say it, but I work for the state of Laramie, but he doesn't even have a policy he put in place for us homeowners in the covenants that he's going to maintain the roads at all.
Right. I was just going to ask, how often has a blade been run?
I've been out there for 2 years and it's been 3 times. And all we do is the ditch pull.
It's not very effective. I mean, sorry, but we had
in this study here, in this study here, in this traffic study, if you read that traffic study that's done by the engineering department, that road's not even up to engineering standards.
Yeah, I'm familiar with that subdivision.
We had a funny email that went around to all the residents about how many tire losses we've had per family. And I thought it would be kind of amusing to hear, but most of us had at least 4 to 5 in the last 2 years. Tire pots in the roads because of the road conditions that are out there as well too. But that's part of it. I'm standing on the fire code. I mean, that's what I've devoted my life to.
I don't think we're asking you folks to do anything about it tonight. We would just like notification if John does want to try to pursue another subdivision or another phase, I should say, that we at least have the option to come and oppose it until he could, or you guys could ask him to address some of the issues that bring it towards you.
Thank you guys for bringing this to our attention. Megan, would you want to help us out with this one?
Well, I don't know that I can help you out at all. Commissioner Gosar and members of the commission, Megan Getz, and I represent Albany County Fire District, who is the jurisdictional fire suppression protection authority for the paddocks. And on behalf of Chairman Hawkins, it's a very big concern. I'm not trying to agree or disagree with what was just made as far as the public comment, but the safety of ingress and egress for fire protection and suppression at the paddocks is a very big concern of the fire district, and they would very much like to have further discussions with the commissioners as it relates to providing that safety for all residents and future residents out there. So perhaps there's an opportunity for some sort of work session or other conversation. In the past, those comments have been submitted as the fire district is required to attest to adequate protection and suppression. And there have been comments that the district does not feel has been resolved. And so just another good opportunity for further discussion on this topic because it is a issue.
Thank you.
Thank you.
Thank you. All right, well, I guess Jennifer and Kurt, you probably heard that. So we got a little more work to do with that one. Thank you guys for bringing that to our attention.
I think Mitch is.
Hey Mitch, please go ahead. Mr. Edwards, you're still muted. There you go.
Mr. Chairman, members of the commission, Mitch Edwards with Nicholas and Tangeman. Can you hear me?
We got you loud and clear. Thank you.
Hey, thanks for giving me an opportunity here. I know there's not anything that you all are going to do with respect to this, but it does have quite a long history with respect to why it is the way it is. The subdivision was actually approved with the conditions and agreements with Mountain Cement regarding these particular roads not having access except for temporary access until City Ranch Road was constructed, and then later having the ability to have emergency access for fire and so forth, but not to allow egress and ingress for the residents onto the road. And I just wanted to let those folks know I'm having a little bit of a hard time hearing online. But I'd be happy to sit down with those folks and explain to them the history of the situation and identify for them that it's not only a haul road maintenance agreement that Neptune entered, but it's also part of their covenants, and it's also part of the subdivision plat with respect to this access. And the access isn't one that this commission can grant to them without Mountain Cement's approval, because they'd be breaching agreements that the homeowners each have with Mountain Cement regarding this access. And there has been litigation in the past regarding the reconfiguring of these roads to connect to City Ranch Road and the closing of this, that the court basically upheld the covenants and plat conditions that were of record. And so I'd be happy to sit down with those folks and explain to them why we got to where we are, what the history of it is, and what the issues are. We understand that there's going to continue to be, as there has always been, pushes to have these accesses opened more or less for convenience than for fire or other safety issues, with those issues being the herring that is put forth to try to get convenience of access. But it's just not something that's going to happen. But if the access needs to be modified so that there's the fire department doesn't have to cut the gate, or the lock, I should say, that's something that the agreements allow for automatic opening and things like that. So it's not an issue there with respect to the type of access. It's just that the homeowners do not have access, either ingress or egress, except for in emergency situations. And so just want to let you know, I'd be happy to sit down with anybody and explain to them and show them the documents that are all of record and that they should have received with their title commitment when they purchased the property, so that they were aware of these issues before they purchased the property and closed. But if there's any questions, I'd be happy to answer them now, but I don't want to necessarily get into the lengthy history of the issue.
Mitch, appreciate it. This gentleman here, please.
Yes.
Commissioners, thank you for your time tonight. Gilbert Sosa, 40 Rampart Road. I'm a new resident in the area, and I understand the history aspects of this. I'm not interested in the history per se. I trust that, you know, every mind that looked into this looked at it from all angles, and where we are today is where we are today. I'm more interested in what are we going to do about the situation? Because the situation right now, as attested to by Mr. Cass, Mr. Garcia, is not to code to the Wyoming Fire Code. It's my understanding that the International Fire Code was adopted by the state of Wyoming in 2006, and that predates the existence of the paddocks and the whole development. So, as homeowners, my understanding is, and you know, we got lawyers in the room and online, they can maybe answer this question. The only apparent recourse a homeowner has in trying to get to a resolution with a developer may be through the Wyoming Nonprofit Corporations Act. Now, if we were to go through that, does that not necessarily bring in the state attorney general and basically the state of Wyoming, as this HOA is a state entity? And in doing so, you know, believe me, I don't want to get into any litigation. I just want to enjoy my time out there in property, okay? But if we were to come to that because the developer is refusing to come to a compromise and work the situation out, and there's probably a lot of different ways to work this out, and I trust, I can only speak for myself, but other homeowners would be interested in coming to a resolution for the safety of everybody. But if we're unable to do that, and we end up in civil litigation, I don't know where that's going to go. I would certainly welcome any insights from the county as to what your position would be were that to occur. This is an issue, I think, that is one of safety. I get all the historic aspects of it. And as I said before, I'm not interested in it. The history, I'm interested in how do we get beyond this and fix the situation. So I'm just going to leave it at that for this evening. And thank you for your time. I certainly would welcome, you know, some insights from the commissioners as to if a civil action comes out of this, where does the county stand? Being that we are where we are. Thank you.
Thank you for your comment. Appreciate it. Anybody else on this one? Okay. Item 10, award the bid for the Albany County Grant Writer Services contract to Wayne Scott Consulting LLC and direct the chair to sign the agreement. Bailey, are you still with us?
I am. Good evening, commissioners. We put the RFP out for a grant writer. We did only get one response back from Wayne Scott LLC. She is who we have been working with previously. I have really enjoyed working with her, and I hope to continue that. So we're hoping you guys will approve that tonight. She was on earlier, but she did have something she had to get to, so she had to jump off, but I'm hoping we can get her zoomed in on one of your December meetings to at least introduce herself to you.
Thank you, Bailey. Commissioners, any questions for Bailey about Ms. Wayne Scott? I entertain a motion for item 10, please.
I move that we,
Go ahead.
I move that we approve item 10 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye. All those opposed, same sign. That motion carries. Item 11, present for approval. Thank you, Bailey. Hope you're feeling well. Present for approval 2022 volunteer fire assistance grant application, the amount not to exceed $20,000 for the purpose of purchasing parts and equipment for Albany County volunteer firefighters. Jed, good evening. Thanks.
Commissioners, this is a grant that comes up annually, and we traditionally apply for it. The types of things that we're looking at purchasing on this grant are the types of things that we're going to purchase anyhow. This grant just gives us an opportunity to recoup 50% of our costs. The finances for our 50% will come from the truck funds that we have, and we have enough to match those. We haven't come up with a final bottom line on what the total will be, but it won't be in excess of that.
Okay. If there's any questions, I'd entertain a motion for item 11.
I mean, that we provided, rather than present it so quickly.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. Motion carries. Thank you, Chad. Appreciate it. Item 12, present for approval, office lease amendment between the Albany County Board of Commissioners, tenants, and the Ohio Federal Credit Union landlord to amend the lease date for the Albany County Prevention Program office space from June 22nd, 2022 to November 30, 2021. Bailey.
This would be the prevention specialists have an office at the Uni-Wyo building. It's currently vacant because we don't have those positions filled. Uni-Wyo had reached out to me a couple of weeks ago and asked if we were still using the office space and if we would be interested in being let out of our lease early. I approached Sue and Jennifer and Christina about this, and we all decided it's probably a good idea to get us out of that lease. And Rob Fisher has agreed to store the furniture until we have the position filled in a new office space to put them in.
Any questions for Bailey, commissioners? I'd entertain a motion for item 12, please.
That we approve item 12 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Thank you, Bailey, again. And it looks like you're up next. Also, present for approval estimated cost of services for Cowboy Moving and Storage, Inc. to move the prevention office from 2020 Grand Avenue to the Albany County Road and Bridge Shop on December 1st, 2021, and the amount of $420 to be paid from the grant. Bailey.
This would just be the moving company. We're going to be hiring Cowboy Moving. I went out for a couple bids to get some information, but these guys seem to come in at the lowest price. So we're going to move forward with them and move things out on December 1st.
Commissioners, any questions?
And Bailey, this is paid by the grant, correct?
Yes, it is paid for by the grant. They agree. I talked with them about it a week or so ago, and they agreed that we could pay for it out of there.
Thank you.
Any further questions? I'd entertain a motion for item 13, please.
I move that we approve item 13 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. So that motion carries. Item 14, request additional funding to be paid to Archon Inc. for engineering costs for the courthouse north entry project to be paid out of the building reserve account in the amount of $55,615.95. Bailey, please.
Commissioners, this is, let's see. I hate coming and asking for more money. It's one thing I really try not to do. However, this project has been very complicated and not set up entirely well from what I keep finding. It looks like the budget that was originally approved for this, something happened and they forgot the engineering fees in there. So now we're short that $55,000 to pay Archon. I don't know exactly what happened because I was not here at the beginning of that project, but I should have caught it after before your budget because I already did ask for some chiller money that was not budgeted correctly, and then completely missed this, and I apologize for that. But this is the amount we're missing, and then as soon as we get this, we should be able to pay the final retainage and get this project finally closed out.
Commissioners, any questions? Yeah, My thoughts exactly.
You can read by more.
Bailey, I guess doing the research that you've done, was that engineering money to be at the original contract, or was that one of the change orders? Wasn't there a bunch of change orders with regard to this over time?
So what I found is the original budget that I found was the 1.6 million. However, once I went back in and found Archon's final agreement, because there was a previous agreement with Archon before the grant kicked in, that total with Archon was 1.6. So that was the total project. So where was then the engineering supposed to come out of? Because in the grant, there's specifically, so this project is made up of 4 different grant funds and multiple other funds. In the grant that's specifically the SLIB North entry, 62,000 was specifically engineering. Well, they had wrapped that up into this 1.6 that then total went to Malone Belton. There was a couple change orders with Malone Belton. The second amendment with Malone Belton, Bill Gorman had approached you guys to take it out of a different fund, which you guys had agreed upon back a year or so ago. But it kind of seems like the original was just forgot about engineering wise. But yet we, the grant still set aside 62,000 for engineering, which we did use on engineering.
So let me just follow up with this. Is this a payment to Archon or to Malone Belton through Archon, or is this through to Archon for their engineering services?
To my knowledge, this is Archon for their services, not for engineering services. Malone Belton was the engineer on the project. Archon was the construction portion, and they had subcontractors to do plumbing, electrical, things like that. But to my knowledge, Malone Belton was the engineer on this, and I did double check with Bill Gorman that they were the engineer.
Yeah, they were definitely the architect. I don't know if they did engineering services too. And of course, Bill Gorman does engineering, but it's, he doesn't engineer the design. He's sort of like the, our owner's rep in a sense. But I'm going to guess that, I looked through all of the, like in the packet, I looked at all of the invoices that, that kind of backed up all the numbers, but it would have taken me longer than I had. And I didn't know what to look for that would be missing. But I'm going to guess that there's a bill in there that's unpaid to an engineering firm, and we're paying the general so that they can pay their sub, because Archon's not an engineering company, they're a builder, right? So whether it's Malone Belton or somebody else. But it's interesting that we don't have the invoice, or we don't know who it is. Maybe it was in the packet and I just didn't look close enough.
I did see it in the packet. Yes, please, Tracy.
I just have a comment to that fact. I don't believe it's that we have an unpaid engineering bill. I believe the original engineering bills were paid out of the Archon money, is how I understand it. And then that left that budget for the Archon for the North Entry short, because engineering shouldn't have come out of there originally.
So we're moving money from one fund, one silo in the project to another because they used Archon's fees.
We
They had to
used
pay their sub.
probably 5 different sources of funding at the very least in this project just to get it to go and be done.
So the invoice is already paid.
We still owe Archon this, right?
Yeah, they already paid the subcontractor, the engineer. They just need to get reimbursed because they took it out of their money.
Right, but that's just part of their
Sure.
cost in
Yep.
doing business. But that's my understanding, and Bailey, correct me if I'm wrong, but the money, Aircon's budgeted money for the project, that's also the engineering pay permit. That correct, Bailey?
Yes and no. I mean, honestly, I think that the original budget was just mislooked. I mean, it was not, I mean, I've had issues ever since I took this on with this project because the initial budget wasn't correct in the first place. The entire chiller grant was used on this project, which you can't do that. It can only be used on that portion. And then the grant itself was split into, the North Entry grant itself is split into construction and engineer. And so that budget has to be engineer. It just wasn't, the invoices that came in, let's see, the contract with Archon was that entire 1.6, which would be all the money total that was budgeted for this project. So there was additional money needed, which wasn't realized until recently.
So Bailey, just a quick question. I see that we have some money remaining in the SLIB engineering, chiller grant engineering, to the tune of about 15.6. Can that be applied, or is that boat sale because we did use it when we could have with this chiller? Does that make any sense to you?
Yeah, that can actually not be used on this because that chiller grant is specific to the chiller portion of the project, which the chiller portion of the whole project came in under budget. That was the first problem, which I did realize before budget. So anything that's under that chiller, so I had actually, Jake looked over the invoice for me from Archon. And then I even reached out to Bill Gorman because I didn't want to screw this up. Yeah. So Bill Gorman was able to break down for me what was actually chiller portion of Archon's final payout for, which then I did take out of the chiller portion, which is the 83,000 under the SLIB construction, and then the SLIB retrofit grant match portion. But because this portion or this Archon pay app is not chiller related, this portion of it, it cannot be paid out of the chiller grant whatsoever.
Okay, and I'm guessing the previous ones that may have been appropriately to the chiller grant, that boat has sailed, and so we're sending back way too much money and paying out some money. So that's how that goes, I guess. All right, commissioners, any other questions?
I have one. Sure. Was this a CMAR project or was this a hard bid project?
It's a CMAR. Yeah, Archon was the construction manager at risk. And they had an amount that they could exceed. It was the 1.6.
See, if it was a hard bid project, they would have to eat their oversight. But when it's a CMAR project, they aren't taking responsibility for all of the costs. They share the risk with the county, and then it ostensibly and likely does save us money because their bid margin is lower when they have a construction fee, a guaranteed fee, rather than having to sort of take on the financial obligations of the whole project and calculate them on the front end, right? So to me, when it's a CMAR, I don't know what happens if they go over the guaranteed maximum price, or if we had a guaranteed maximum price. Mr. Chairman, I'd love to look into this a little bit. I don't know that I'm prepared to vote on paying $55,000 until I understand who's responsible for what.
Yes, please, Jack.
Mr. Chairman and Commissioners, the reason why we are looking at having to make the payment now is because we've advertised already that the final payment is due within 40 days after the first day of publication. And that payment should go out on December 3rd. And so certainly if you want some additional time to review and look at this, I mean, we've pulled out the invoices with Bailey's absence today. Amanda, Kayla, and I have been looking at it, and so has Tracy, to make sure that everything does equate to what is on that piece of paper, the breakdown, basically. And so you really do have a few days if you want to wait.
Well, oh yeah, and we have to schedule a special meeting to appoint an assessor.
Right.
So in that case,
But the reasoning for the approval of the payment is so that we do have the money to pay out our con on December 3rd.
Okay. So Jackie, could we table it? As long as we had an approval by December 3rd, is that correct?
Yes, that's correct.
Commissioners, your pleasure.
oh, I just moved it to table it, to shift it to an agenda further out, and so we can get a little bit of information.
Moved and seconded. Do you need a more specific motion than that, Jackie, so that it's paid by December 3rd?
Mr. Chairman, just as a refresher for you, you do have a work session scheduled on December 1st with City Council and the Albany County delegation. If you want to have a special meeting prior to or after that, that certainly gives us some more time to look at this, and then we have a fixed time for your approval and for consideration.
Okay. Is it motion enough for you, or do we have to spend it, put a special time?
Commissioner Richardson would mind adding to be determined on or before December 3rd. Make sure we meet with the clerk's.
Well, I mean, I think that, I don't think that has to be there, because we just know that.
You don't have to.
Okay. The point I was making is that because we're time limited on when we appoint a new county assessor. And I think if I do the math in my head right, we don't have until December 1st. We're gonna have to do that. I mean, are we in the 5 days that we have to do it now at this point? That's a discussion later down.
Well, Mr. Chairman, Commissioner, to answer your question, you have been notified by the Democratic Party of the three names that they have submitted for your consideration, and that notification came to you last night via email.
Yep.
And so the clock has started.
And it's a 5-day clock.
Right.
So it seems to me that we would just, like on Monday or something, we would. I don't know, that Monday's after 5 days.
Your 5-day clock expires Saturday evening
It's
at the
not
time.
business days, it's day days.
All right.
Yeah.
So it seems to me that we would deal with that
Okay.
at the same time as that.
Okay.
Because I don't think it's that hard for us to sort of, I mean, I can't tell if this is just a narrative, the narrative behind the agenda item maybe is just not totally sorted out. I don't really think there's a big issue here.
It's been moved and seconded. Any further discussion? Hearing and seeing none, all in favor signify by saying aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Item 15, present for approval, approach license for Dean Ed and Cindy Case Spicer, on Dutton Creek Road in section 10, township 17 north, range 77 west of the 6th prime meridian. Rob, thanks for hanging in with us.
Yep, good evening, commissioners. This purchase license that the Spicers would like to get to gain access from their property to Denton Creek Road. I have looked at it. It does meet all the site requirements.
If there's any questions, I'd entertain a motion for item 15 if there are none.
I move that we provide 15 as presented.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all in favor signify by saying aye.
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 Aye, all opposed, same sign. That motion carries. Item 16, present for approval. Thank you, Rob. Employer benefit agreement between Albany County and Medical Transport Solutions, a division of Medical Air Services Association, Inc., for a term of 1 year from effective date. Amanda, thanks for joining with us.
Hello.
Hi, Amanda. How are you?
Good. How are you? Sorry.
Good.
I have Lynn who is going to present on behalf of MASA. So I'm gonna let her go ahead and give her spiel and tell you about the contract changes.
Thank you, Amanda. Am I on?
Go ahead, please. Yep.
Okay. Good evening, commissioners. Thank you so much for time on the agenda. I'm happy to be here tonight. I also have my colleague and regional director, Andrew Zink, who's on. But anyway, we are coming to you because you have provided MASA Medical Transport Solutions coverage to Albany County employees for the last few years. And we are looking at changing the agreement. You're currently on a census plan agreement, which is employer provided, but we want to move to an employer provided agreement, different name, but kind of means the same thing. There are a few little differences the way the agreement works, but bottom line, it is going to provide much better data for Albany County and MASA, better records kept and that kind of thing. The other portion of the agreement is that, and it's not because of the change in the agreement, it's just there were legislative changes in Wyoming last year in 2020 in regards to medical transport, and MASA became an insurance product due to those legislative changes in Wyoming. But we gave a 1 year transition price. And so now we are 1 year out, and that price increases about, well, it's exactly $68 per employee for the 1 year of coverage. So that moves from 160 to 228, again, annually per employee. Please recall this benefit does cover the employee and their family. So just asking if we can change that agreement so we have better record keeping both on our end, on MASA's end, and on Albany County. I've been working with Amanda and Christina for the last few years on this, and this new plan gives them portal access 24/7 to live data on who exactly is covered. And again, it's not because of the change in agreement, it's just with the changes we've had over the last couple of years, legislative changes in Wyoming, we have had to increase the price. We set in a transition price, and you are now 1 year out of that that pricing. So we move it to that 228.
Thank you, Lynn. Commissioners, any questions? Lynn, I just do have a question. That's 40% increase, doing the quick math. Can we expect that next year? Or I know you can't see in the future, but you do have probably actuary help. What's your thoughts on that, please?
Lynn, let me take the question. So this is Andrew, Regional Sales Director for the Midwest. So I joined with Lynn today. So kind of the growth of our business is we've had a B2B division since 2015. So fairly new out there in the market. We went out with a standard price to all states back in 2015. As a part of our growth, we've now expanded into becoming an insurance company in 23 different states across the United States where they deem that to be insurance. As a part of that growth, we've looked at market segmentation and just utilization from a standpoint of what our cost is to do transports in certain geographies. And so now that we're a little more sophisticated, we've been able to determine where we need to be on a bottom line revenue for a state like Wyoming, where you don't have any level 1 trauma centers. And we know individuals, if they have a situation where they're going to fall in the golden hour and need to be transported, it's going to be transported out of state via air with an increased cost associated with that. So that has to do with why the rate is being set at what it is going forward into the future. Our determination is not going to be to adjust that rate on a group by group basis at this point. We're not looking to necessarily do that, but more on a state or geography basis. Does that make sense? What additional context can I provide around that?
Well, it does make a little sense, but then I'm guessing that Laramie's closer to level 1 trauma centers than, for instance, some place in the western Wyoming. Would you offer the same contract to Laramie as you would to, for instance, Big Piney, Wyoming, or do they have to pay more?
At this time, everyone pays the same rate in Wyoming. If they're a Wyoming resident, the rate would be the same.
Okay. Is there any movement in your industry to maybe segment not only by state, but also regions in those states, or is that not something that you guys generally do or is not done in the industry?
So right now we're really in the process of becoming insurance in many states. In those states that we're insurance in, we have to have regulated products and regulated rates, so on and so forth. So like the past year, we were an insurance product in Wyoming. So, when we're an insurance product in a particular state, it's more of a set-based price structure versus, a situation where we're a membership program in another state and you might have a little bit more elasticity.
Okay. And so then my guess from all of this, and thank you for the context, is there might be an increase next year, but 40% would be something that we probably shouldn't expect, or what's your thoughts?
I would say we really don't anticipate a price increase next year. In fact, I was going to bring up a completely new plan to you guys, but due to the timing of your renewal, which was 11/1, we don't have quite everything we want to show you with that. So next year, we might show you a new plan and see if you're interested in that could potentially decrease the cost.
I like what you're telling me, Lynn. Thank you so much. Yay. Well, Commissioners, any questions?
Mr. Chairman.
Sure.
Lynn, do I understand correctly? Our rate is based on, it's a Wyoming rate because this is where we are, but the coverage actually follows us all over the country and the world.
Yeah, that is correct, Commissioner. However, you guys have the Emergent Plus coverage, so it doesn't follow you across the world. It covers you everywhere in the United States and Canada.
Gotcha.
Okay.
I couldn't remember, but I knew there was some sort of international aspects to it.
Yes, there is that option. But yeah, the
It's interesting. If we were in northeastern Colorado, or there are places, we're closer to trauma centers than lots of places like, say, in Colorado, but they get a different statewide rate just because they're in Colorado, right? It's not a distance thing. It's just
right now these rates apply to two states. Correct me if I'm wrong, Andrew, but Wyoming and Florida. Florida, where our headquarters is at, is also insurance. But we moved to that Emergent Plus and MASA. What we wanted to do, rather than having one larger price increase, we did a transition price for you. Rather than move right to this 228, we held it at 160.
We do have increased and different rates in numerous other states.
Oh, okay.
Commissioners, any questions? Not an entertain a motion for item 16, please.
I move that we approve item 16 as presented.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye.
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 Aye, all opposed, same sign. Motion carries. Thank you, Amanda. Thank you, Lynn. Thank you, Andrew, for joining us tonight for the
Yes,
question.
thank you very much.
Thank
Have a
you.
good evening.
As well, 17, present for approval, Fourth Amendment to inmate telecommunication location agreement between Telmate LLC and Albany County Government. Sheriff, Albany.
Evening, commissioners. This is a change into our contract to represent some changes in the FCC for caps on jail inmate call rates. Reflects it in the document to cap it at 21 cents a minute. So Telmate's required to do that by the FCC, and because our contract's with Telmate, we're then required to comply with the FCC as well. So that's what you have.
Thank you, Sheriff. Any commissioners' questions? I entertain a motion for item 17, then, please.
I move that we approve item 17.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Item 18, present for approval, invitation to bid for purchase and delivery of 3 full-size 4-door, 4-wheel drive or all-wheel drive sport utility vehicle with upgraded suspension and pursuit or police package specifications and direct the clerk to advertise. Sheriff again.
Yes, this is an invitation to bid for 3 police package SUVs, also trade in some of the older vehicles that we have that aren't currently being utilized or cannot be utilized due to basically either age or repair status with some of the things that we have in there. So all of this money comes paid for through our portion of the 1% tax that we have there too. So to replace some of the vehicles that we have that don't meet those standards, and trade in some of our older ones so we can lessen the cost.
Commissioners, any questions for the sheriff? And entertain a motion for item 18, please.
I move that we approve the invitation to bid for purchase and delivery. 3 full-size 4-door, 4-wheel drive sport utility vehicles with police package specifications and direct clerk to advertise.
Move and second. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Thanks, Sheriff. Appreciate it. Your time.
Thank you, Commissioner.
19 and 20 were handled earlier, so we will move to item 21. Take from the table the petition to vacate a portion of 3rd Street, in Albany County, located in Centennial Plat, requires survey and direct the clerk to advertise. I guess we don't.
You need the motion to take it from the table.
Yeah, Mr. Chairman, I move that we take from the table the petition to vacate a portion of 3rd Street in Centennial.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries. Item 22, present for reconsideration, petition to vacate a portion of the 3rd Street in Albany County located in Centennial Plat. Require survey and direct the clerk to advertise. Jennifer, thank you.
Yes, and I apologize for sending out the updated procedures last night and not sooner. It took me longer than I thought to get through the end of them. But what you have in front of you is an amended viewers report from Karen, who's also here and can speak about her viewers report. After our last meeting, I spoke with Mr. Lang, who is also here in the audience, should you have any questions for him. And he indicated that the Mallows, who own the property just north, had done some significant development to the road that they used to access their property since Ms. Bowman had done her viewers report the first part of August. So we asked that Ms. Bowman go back out and update her viewers report to reflect the current state of the property and give this commission a clearer picture of the fact that Mr. Mallows
if the commission were to approve the vacation as been requested, it would not impact Mr. Mallow's access to his property. He's already developed what he needs in there. And after our last meeting, or at our last meeting, we spoke some about Kayla's conversation with Mr. Mallow and that he had no continuing objection to the vacation when it went out now. The procedure has changed from last time. So what we need from this commission now is a decision on whether or not to approve the requested vacation as it is or in some modified form, or to deny it. And if it is approved in some form, then we would direct that a survey be done to get a legal description for the portion that the commission has approved vacation of. And after this meeting, the notice will go out to the landowners, giving them 30 days to file any objections if they have any, or any damages. And then if there are objections received, then there's a whole procedure that we go through. If there's not, then statute says that at that point, we have the survey, we could record the quit claim deed and have the final approval from this, to finalize the loose ends from this court.
Jennifer, is the survey paid by the homeowner?
Correct, by the applicant.
If there's any other questions?
I just have one, and that is, there was really only one option given, and that's to vacate 20 feet along the north edge of the petitioner's property, and so I'm trying to figure out how I'm going to make the motion in words that can be translated into basically a decision that a survey could be based on. Does that make sense?
So if what the motion that you intended to make was to approve the petition for vacation as written, then it would be to vacate that 20 feet on the northerly property line. And a general description is fine, because we wouldn't have a meets and bounds description until we have a survey.
Right.
But that would be stated in that. Doesn't necessarily necessitate that you put that in motion.
Correct.
Gotcha. Mr. Chairman, I move that we approve the petition to vacate a portion of 3rd Street in Albany County, Centennial Plat. That we require a survey and direct the clerk to advertise.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all in favor signify by saying aye.
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 Aye, all those opposed, same sign. Motion carries. Thank you, Mr. Lang.
I'm Larry Lang. I thank you for your consideration. We've worked with your staff for about 1.5 years to get to this point. And I've done other restoration projects, and I'll make the community proud.
Well, thank you, and thank you for enduring with us through this transition. I really do appreciate your patience with us. Thanks.
The restoration is needed, and your neighbor, Mr. Mallow, is a good guy.
We're getting along.
I went and looked at what was done there, and somebody should have done that about 70 years ago.
Mr. Lang, did you ever know Richard Guzzi?
I'm sorry.
Did you folks ever get to know Richard Guzzi?
Yeah, I purchased the house from Rick.
Correct. Oh, okay.
And I gave him a living estate, and we became pretty good friends. Unfortunately, we all have that day when we get to go out.
Right.
Not down.
All right. Well, thank you all. Appreciate it. Have a nice evening. Item 23, set special meeting to appoint the county assessor. So it looks like the 5 days started yesterday. So that puts us to the 20th would be the last day. What does everybody's Friday look like?
Friday was good. I obviously couldn't do it Saturday.
Okay, what time on Friday works the best for anybody?
I'm free.
I just have a meeting at 9, but I'll be free at 10. Would that work? Yeah. Okay, can we make a meeting for 10 on Friday the 19th of November.
Mr. Chairman, I move that we set a special meeting to appoint county assessor at 10 a.m. on Friday, November 19th.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. Motion carries. Thank you so much. Item 24, discuss office space in the courthouse. Which is, so I'm guessing, I'll take the lead on this one, and then people help backfill me where I go off the beam. There was since Christina in Human Resources has moved to what used to be, oh gosh, was that drug court and previous IT. That leaves her office open. So Judge Sanford and I worked out an agreement. He would like that office for victims a couple times a year. Once he thinks that it's a great place for security, especially in domestic violence court proceedings. I agreed that was a reasonable thing. And so if he was reasonable with us having it the rest of the time. So I talked with Jackie at the clerk's office, and like this room, there'll be some sort of scheduling software or paperwork that's done to set that aside. And so that takes care of that.
Who will be doing that schedule?
Is it you, Jackie? What is it I had to do?
You're gonna call the Jackie.
Let me just give you a little bit of history.
Okay.
Basically, I don't know what means. We have been the keepers of the calendar for the use of the commissioner's room because it's being used quite often more and more. And it has become habit that when there's a department that needs a space, they come to us and we make arrangements of the availability for the use of the room. I mentioned to Pete that if we have the same format upstairs, I'm willing to do the same. I know that Christina had some suggestions that making it open to everybody and then a first come, first served basis. Who the keeper of the key will be for that room will be unknown, or how to obtain access. But maybe Christina wants to chime in on that discussion.
Yeah, I know, I was upstairs. Good evening. So my thought process behind it all is that we would have an open access calendar for everyone. That way Jackie doesn't have to maintain it. We're all adults, and so I feel like if you look on the calendar and there's somebody scheduled there, you can't have the time. And then if it's open, then you just put in whatever time you need, and that's how we'll manage that calendar so that no one has to approve it or manage it or approve or deny any requests. The calendar would be open to both district and circuit court as well for the use of victims when they have trial, so that they can schedule in where they need to be. And talking with Judge Sanford, he liked that idea as well, as long as they could block off time, and then, you know, everybody else can schedule around that. And so I thought that would be amenable for everyone. The only question that we have regarding the calendar is whether or not the state employees have access to that calendar. So we've got to work with Adam to see if we can make that work so that they can add their own time onto that schedule. In regards to the keys, there's not going to be a whole lot in there other than the conference table and chairs, and then a TV and a computer, so that if we have to Zoom or do anything like that, everybody has access. And so Adam and I haven't had a chance to talk about it. My thought is that we just leave the room open and unlocked the days that it's got people in there. So there is no badge or key entry to access it, and then we'll lock it every night at 5 o'clock. I'm pretty sure he can set that up automatically on the door lock system, and that way we don't have to distribute keys or issue badges or any of that to cause a problem for people to not be able to get in. So that's my general idea. If you guys have any thoughts or comments or feedback, please feel free.
Does that door already have a badge scanner?
It does.
So we could just enable everybody's badges.
We could, the only thing is, I don't know that everybody needs access to it, and not knowing who scheduled the room. That's why I said if we just leave it unlocked from 8 to 5 during business hours, then we wouldn't have to grant any access.
Right now. The only question I would have is, I'm sure they know the court's schedule in advance, but I'm sure maybe not as we would think. Sometimes they settle when they think there's gonna be a trial and not. So just having priority for them or for their folks, so that there was a place for a victim or witness or whoever needs to use that room. I will figure that out, but that can be figured out.
And when I talked with Judge Sanford about it last week, he said that they could provide us, if they couldn't get access to the calendar, they could provide us with what they have on the calendar, and Jackie or me or somebody can put that in. And then if it cancels, you know, we can go in and delete those. But my hope is that Adam can work out a way for them to have access to the calendar so they can just answer that all on their own. And that was something else he said to me. He just wanted to ensure that they have priority if they need it for a victim. And I said, that's my understanding of talking with Jackie and from what you had said. And so I didn't think it would be a problem.
Yeah, Jennifer, looks like you have something to say.
The only thing I was gonna say is sometimes if they have a protection order hearing or something that comes up, they don't necessarily have that known weeks in advance. So long as we give the courts the ability to have priority scheduling, so they can schedule their things in advance if they know, but if something comes up, as long as the other participants in the county know that there is the possibility you could get bumped if the court has something that comes up and they need it. I think that's fine.
Okay.
And as long as communication goes out there from the get-go, that the court has priority.
Correct. And I hadn't had a chance to follow with Jackie since then, but what I told him, because he did mention that, was that if he let Jackie or myself or somebody know, that we can notify whoever's scheduled and let them know that they'll have to find another location. And he seemed okay with that, so.
Super. That little room that's next to it that they've used for court type stuff, it's still there, set up the same way, right?
Correct.
And they still use it for that, right?
They do. They hold court hearings in there.
Well, I mean, we need the space for everybody to use, and then the courts should be able to use it too. I'm gonna guess that the reason maybe that other room isn't adequate in size, or it doesn't have the right furniture in it.
No, sometimes they have to separate people out. So one of the things that he talked
They
about
use
was,
both.
yeah, so they almost had an instance a few weeks ago where they had a mistrial because they had the parties together and the victims were there and they just didn't have enough space to put people in individual rooms, which they're supposed to be doing. And so sometimes they're full and that's why they need the overflow of the space so that they can utilize both and keep everybody separated.
Gotcha. Somebody's gonna have to stand in the stairwell.
It is a coordination problem sometimes for victim witness. They have people on all the floors and the poor coordinators are running up and down and back and forth and reminding their witnesses, don't talk to people, don't talk to them.
And he told me it'd be about a half dozen times a year,
Yeah.
probably at most.
It's
So,
not a ton.
yeah, awesome. Hopefully we got that one ferreted out. And then, is there anything else on this? Was this?
Or your office?
Sure.
I mean, do you want me to make the announcement? Or is that what we're doing? or no?
What we're negotiating.
Okay.
Okay.
So with the limited space that is here in the courthouse, we had an idea of trying to utilize the space as best as we can. So as you know, HR took over 304. There's only 2 of us. There's 3 offices in there and then a main central area. And so originally the conference space was going to be on the 3rd floor, but because the judge and you guys talked and everybody's amenable to sharing the space, we've moved that upstairs. And so our tentative thought and plan for the 3rd floor is my office is in there, Christy's office is in there. Potentially we would like to bring up payroll and put payroll in one of the offices as well. So she has a private space. The plan then from there, and I don't want to speak on Jackie's behalf, but I'll keep going unless she wants to jump in, is that she's going to potentially move grants to the back where elections is in her office right now. They're going to put up a wall divider for Bailey to have privacy when people come to meet with her. And then they're gonna move elections into where Amanda and Bailey currently are. Jackie had expressed that there was some concerns and some issues with elections and the public having access and all of these things. And so we felt like that might be the best use of space. Elections can have their office, where the public can come in and out without going behind the counter in Jackie's office. Grants would have a private section in the back. And then Amanda would be up with payroll, which works because my new position and payroll will work together. And she will assist with payroll. And then Amanda, myself, and just HR in general, we work so closely with benefits and other things, so that collaboration would be beneficial. The middle space there in 304, Jackie was looking for a space to put all the commissioner files so that those get scanned in, and so that the renovation can start down here. So we're gonna potentially move all those filing cabinets up to the middle space of 304. We'll create a desk up there for one of her employees, whoever's gonna scan, to come up and scan all those files, and then we'll remove those filing cabinets as they become empty. And then so eventually that middle space in 304 will be vacant. We can talk about if there's needs for it at that time, but then that also allows Jackie a space to get all those files scanned and get that project done as well. So tentatively, I think that's the plan. Is there anything else you'd like to add, Jackie, or?
I just want to say that I appreciate the fact that we're working on, we are cramped for space. The need of having better access for elections is becoming more and more apparent. As we head into the 2022 election cycle, we are getting more and more individuals coming in. We're not allowing anybody to go back to the back area at this time. And so that will free up the space to allow us to make the move. I did speak with Bailey, or we did speak with Bailey today. She was amenable. I would like to make a request to the county attorney, of which I have yet to do. So, Mr. Attorney, please apologize in advance. But we were hoping that, to allow some sound barrier back in the area where Bailey used to be, to use the glass partitions on the counter that I already have to maybe help separate the sound a little bit, to give them a little more privacy. I know we have some material that we can use also, but I can remember those nice partitions that were tall, and it would save us money and just a little bit of Roy's time to get them positioned in a place where it will allow a little bit more privacy for Bailey back in the Rats area. So we're all working together as a team and appreciate that. And my staff does not know this. It's going to be a surprise. Probably know now, but it's work in progress. But we have. I just appreciate some more room. I really, really do. And thank you for allowing us to work together to do that.
Yeah.
And for your consideration.
Yeah.
It's nice to see that collaboration among all you guys to try to improve space and all. Jackie was where Amanda and Bailey are now. Wasn't that once election already? I thought I had to go in there to vote.
If you could believe it, it used to be the county commissioners group. And so commissioners proceedings and meetings
and
were
that did take place.
And that, yeah. And so those were the days. But it did used to then become elections, and it basically it's a great ingress and egress for the public to come and go. But when we had some concerns about allowing employees some privacy when they have to talk about benefits or issues with Amanda, we moved Amanda into that space. And then we inherited the grants office and put basically grants back to where they were, and then squished elections into the middle part of the office. Well, that didn't work either. And so Now this will allow us to put elections back to where they need to have, the public needs to have better access, especially as we approach the new election cycle. And so, yeah, that's been interesting. Land office used to be the extension office. I can give you a lot of history about the courthouse. This used to be circuit court. So, yeah, a lot of changes.
Because the jail was upstairs.
Yeah.
So was all the furniture moved out of drug court there?
Yeah.
And moved across the street?
Yep, so drug court is moved across the street. My office is down on 3rd floor currently. And we are waiting on the conference table. It should be here next week. But the chairs are here, so that'll be finished very quickly. And then Jackie and I and the movers have been discussing about when all of the move will take place for her and her staff. I suspect it'll be done no later, as long as everybody still is amenable, that it'll be done no later than probably December 10th. So, because with the holidays and people being gone on vacation and trying to schedule movers, we just couldn't make it happen. And Jackie needed a little bit of time to, I don't want to say clean up, but clean up and go through some of the commission files down here. So that way what we're moving up is what actually needs to be done and we're not wasting space. So.
Do you have anything to hang on the walls in that conference room that was your office? Or is it gonna just be like bare white walls?
There isn't anything currently, no.
Okay.
I'm sure if you want to get real creative, if you talk to Stacy Lamb, I know there's hundreds of puzzles that Janice put together that we could put up there that are framed.
No, we're not gonna hang framed.
But other than that, I don't have any options for you currently.
No sugarcoat it. Commissioner Richardson, tell me what you think. All right, well, thank you guys, I appreciate it.
I might have a really nice picture of Towner Lake and a snowy range that I could hang in there. Okay. You know, that would totally fit.
Item 25, discuss the formation of an audit committee. And so this was a conversation that I've been having in my head for a little while, and thank goodness it stays there until it's closer to restaurant quality. It seems that there might be some opportunity for us to see, to look at the books and the accounts of some of our boards and commissions on a more routine basis. Maybe twice a year, maybe quarterly, just so that we're up to date on where they stand in relation to where they say they stand. I think there have been some surprises over the years, in my 3 years, and I don't know that it's a person problem. I think it's a systems problem. And so this was an attempt to bring those together and say, when you are working at underlying board, every 3 months or every 6 months, could you bring us your income statements and verify it with bank statements or whatever, just so that we know that we are where we're supposed to be. And if there needs to be training associated with that, or if there is something that we could be helpful to, then we know about it before it becomes a 2 or 3 year problem, and it's more of a 6 month, 3 month, yearly problem. Tracy, would you like to add to that, please? Thank you.
We do have probably going to be a significant finding on our upcoming audit due to one of these boards. I don't want to go into the details, and that this isn't the venue for it, but I'm fully supportive of this audit committee because I think it also creates accountability. It would give these other boards also maybe some guidance and help and helping them find the right answers or how to do the things correctly. And just sitting here tonight and talking about the Archon issue, why couldn't we throw project management under this committee as well as an oversight of the checks and balances of balancing those big projects out? Because I know Bailey does a great job in reconciling the grants, but that's just the grant piece, that's the funding piece, and that's not always the whole big picture of everything. Maybe there's other things. Amanda and I also had a conversation today about our accounting software does some project management, which could take Archon, the project, because we paid it from so many different funds and house that for us. But of course, that's going to take probably a little training because we've never done that before. But I think it would be a great improvement to move forward. So just those thoughts is, what I've had with our discussions and Jackie, talking with Jackie, and then just tonight.
We don't need a decision tonight, but just kind of your thoughts on that. If it's a bad idea, we'll just kill it right tonight. If not, then maybe we should think about it a bit more.
It's interesting. We sort of already have an audit committee, and I'm looking at them, right?
Right.
But we don't have an audit like structure, so generally you're reacting rather than being proactive.
Exactly.
And it might be save time in the end, because it's a lot harder to fix things than it is to catch them.
Significant findings on our audit can cost us grants.
Mhm.
It can cost us more than just a financial bailout of whatever board it could be. It's not good for anything, anybody. It can also make newspapers.
And it stresses you out, because then all of a sudden it becomes priority number one.
Yeah.
At a time when you have other things to do, and it can't be priority number one, and that happens.
Exactly.
Right? And you guys always rally, and yeah, I like it.
I know that personally, I can dedicate, whether we decide on quarterly, monthly, or whatever, I can set aside time to do that and fulfill those obligations rather than get appointed to a board.
Right. Mr. Chairman, how detailed are the, we get monthly statements from these entities, but there's no audit portion. I mean, it's like here, but if there was a mistake, nobody can see it, right? So sort of the first half of it is done, but I don't know if that's complete enough or thorough enough to do what we're talking about. Does that make sense?
It does. And I think also, you can start to see a pattern when the reports start coming in. You don't really have a way to trace it that, oh, shoot, suddenly there's no reports for these people, and how can we get them back on track? I think a system with a committee where it's not just all reliance on maybe Jackie's office because they show up on your agenda with these reports. I think another system, where we have a group of people looking at these things, and then we can actually check a box or whatever the formation or formality of it's going to be. I think it's in everybody's favor to stop and say, okay, we're having some issues, and I'll pick on South Knoll because we know South Knoll's having problems with getting people to do things for, volunteer, because everybody's busy, but we can say, oh, South Knoll has dropped off the agenda for 2 months now. Let's get with them and figure out what's going on before it becomes a crisis, or the state wants us to pull their charter or their, not charter.
So we don't have an attendance sheet, a completion sheet. It's your basic spreadsheet checklist, and then a process to follow up with it.
Right. And also, checks and balances of having the financial statements reviewed before they go to auditors.
So we take statements and publish them in our consent agenda, but we don't scrutinize them.
Right.
It's a completion grade only. It's not in the grade book. It's not a.
And I think this is an opportunity to standardize the process and then also provide education, not only for that, because, I become a treasurer of a board by just going to the bathroom on the wrong part of the time, right? And having that education piece, but also probably help us during budget to help people that are volunteers understand our budget process and be quicker for us and also less demanding on them. So.
And when those people exit to the restroom and become treasurer, they oftentimes don't learn that they also have to file a bond with my office.
Right.
And that would be great to be able to capture that in here too. we do our best. We try to put them on the calendar and remind ourselves of these bonds, but inevitably we miss one and then it becomes, oh gosh, you better get that in, otherwise we gotta hold your money.
Would you guys help us out, figure out, it seems like everybody seems to be, what might be useful to you or what you could do time-wise and then what that might look like. There needed to be somebody from this board on it.
I think, initially we need to sit down and brainstorm and look at what the true statutory requirements are of some of these boards and reports for the boards. Right? I think that's just gonna just take all of us knowing our own expertise in areas like my bonds for giving out public funds, Jackie's with the commissioners' agendas, and then you guys probably as a rulemaking board, and try to figure out what's needed, what's the bare minimum, how soon can we react and jump in there. So kind of maybe sitting down with all these ideas and formulating, for lack of a better word, bylaws or
draft policies and procedures.
Yeah, exactly. Yeah. And going from there. And then as far as the internal stuff, I think that would just be as an as needed basis. Plan for that, project management. This is another set of eyes. Like I said, Bailey does a great job, but maybe another set of eyes that find formulas that are missing one cell above or things like that. Yeah. Or maybe even software to manage projects, specialized. Because our accounting system will do so much, but I don't know, because I'm not familiar with this. I didn't know we even had this module on there, but there could be maybe better software.
Yeah.
For project management too.
Yeah, if we could avoid a $56,000 bill that we're looking at here soon, it'd be great. Money well spent. So.
In addition, the last thing I want to add is perhaps each of these boards that report to you guys as commissioners could appoint their liaison and maybe have some kind of an attendance requirement, whether it's twice a year or quarterly or something to that effect. But
you would need a training session with everybody at it so you could say, hey, look, here's what we expect.
yes,
Otherwise, you'd have to duplicate that conversation over and over again.
we did a training session with some of the special districts. I want to say that's probably been at least 4, maybe even 5 years ago now, because Linda was still in office when we did it. And so that's been 3, but it's been a day or 2 since we've done it, but that would be a great way to jump into this. Is, hey, we need these things from you. And
we can add it I can add it to the board training that our office does as well.
you guys do a board training too?
We have started. We've done planning and zoning and fair, and we have library tomorrow.
Thank you guys for doing that. That's super cool.
That sounds super great. Like maybe we should just let you guys.
Right.
In my experience, attorneys don't.
Numbers aren't good.
And accountants aren't attorneys either, so I'll call myself out on that. But maybe we can.
But if there are specific things that you want us to put into board trainings as a reminder, when there's new board members that you have to have a bond for your treasurer that has to be filed with you guys, all of those things, we can add that in.
Yeah. It can never hurt to have them be told multiple times.
Sure.
I mean, they're volunteers doing important jobs too, but they're not experts in it, or their day job doesn't mean that they are experts in what they're volunteering to do.
Yeah. Well, I love the project management piece of it too. So I think that's something to be useful too. Thank you for thinking about that. All right. Thanks, Tracy. Thanks, Jackie and Jennifer for helping us out with that. Item 26, approved payroll and vouchers for November 2021. I entertain a motion.
That we approve payroll and vouchers.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
All those opposed, same sign. That motion carries. Item 27, executive session pursuant to Wyoming statute 16-4-405A III. I entertain a motion for that.
I move that we exit regular session and move into executive session pursuant to Wyoming statute 16-4-405-83.
Second.
Moved and seconded. Any further discussion? Carried, seeing none, all those in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. That motion carries, leaving regular session, entering executive session at 8:54. I've got some work to do here.
That is some decent tech, isn't it?
Start recording again.
And then allow the participants back from the waiting.
Here, but with nobody.
Okay.
So,
Mr. Chair, I move that we exit executive session and return to regular session.
Second.
Moved and seconded. Any further discussion? Hearing and seeing none, all in favor signify by saying aye, please.
Aye.
Aye.
Aye, all those opposed, same sign. Motion carries. Item 30, action if needed regarding executive session. There is no action required. Item 31, seeing no more business before the county commission on November 16th, 2021. I move to adjourn the meeting. Thank you all and have a great evening. Good night.